Good afternoon. I'm delighted to introduce Barry Cushman, the James Monroe Distinguished Professor of Law. Usually at these events, the dean says a few words about the person for whom the chair is named. That, I think, will not be necessary on this occasion. It is, though, perhaps worth noting that the Monroe Chair is one of our oldest, having been established in the early 20th century with a grant from the Carnegie Foundation. The grant, although undoubtedly generous by early 20th century standards, was small enough so that with even the better part of a century's appreciation, the chair was until very recently underfunded relative to most of our newer professorships. And so for a time, many of you will remember that we used it for a visiting professor. Fortunately, Deans Scott and Jeffries, the Law School Foundation's board, and most importantly, David Harrison, all agreed that it made no sense for a chair with such a distinguished name to lack the financial wherewithal to support a distinguished faculty member. So ultimately, part of Mr. Harrison's bequest to the law school was used to increase the funding for the Monroe Chair, together with the Madison and Minor chairs, which dated from the same period, up to the level of a distinguished professorship. And distinguished professor is the right phrase to describe Barry Cushman. His work on the Supreme Court in the late 19th century through the New Deal era pulls off the rare feat of being innovative, contrarian, and persuasive at the same time. Since the legal realists, scholars have tended to see legal change as driven primarily by external economic, political, and cultural forces, and to attribute a diminishing role to the internal development of legal consciousness expressed in doctrine. Perhaps nowhere is this more evident to the layperson than in a story about the New Deal that I learned in high school, and indeed I suspect that Helen and Lydia Cushman learned it in much the same way. The story of the switch in time holds that much of Franklin Roosevelt's New Deal policy ideas were thwarted by a group of reactionary justices, the Four Horsemen, who were firm believers in laissez-faire. Roosevelt fought back with the court-packing plan. Although he lost that battle, he won the war because the Four Horsemen, frightened by the threat of institutional evisceration, backed down and ceased to find New Deal legislation constitutionally defective. In the early 1990s, Barry published a trio of outstanding articles that challenged this conventional story head-on. In the first two, entitled Doctrinal Synergies and Liberal Dilemmas, the Case of the Yellow Dog Contract, and A Stream of Legal Consciousness, the Current of Commerce Doctrine from Swift to Jones and Laughlin, Barry rediscovered the complexities of substantive due process and Commerce Clause jurisprudence, respectively, in the late 19th and early 20th century. He argued that those doctrinal complexities were adequate to explain the differing results in seemingly similar cases. To take one simple and well-known example, courts at that time took seriously the idea that some businesses, like common carriers and utilities, were affected with a public interest and therefore deserving of less solicitude in substantive due process analysis. We can thus make sense in purely doctrinal terms of cases that disallowed yellow dog contracts when entered into by a common carrier, but then allowed them when entered into with manufacturers. Applying the same scrutiny to Commerce Clause doctrine, Barry showed that there was no sharp discontinuity after President Roosevelt's landslide re-election in 1936. Having thus showed that the pattern of cases involving constitutional challenges to business regulation could be explained using the doctrinal categories that contemporaries actually used, Barry then turned to the alternative claim that raw politics provide a superior explanation. In his article, Rethinking the New Deal Court, Barry used a careful parsing of the historical record to demolish the claim that the 1937 decisions upholding New Deal legislation, beginning with West Coast Hotel versus Parrish, were a reaction to the court-packing plan. he also provided additional support for the proposition that the results can be explained once one understands the contours of substantive due process and Commerce Clause jurisprudence at the time. Berry tied those strands together in his book, Rethinking the New Deal Court, The Structure of a Constitutional Revolution. The book was awarded the American Historical Association's Littleton Griswold Prize in 1998, which happened to be the year he returned here to his alma mater from St. Louis University Law School. Berry has continued to explore the interconnections between substantive due process and Commerce Clause jurisprudence during the late 19th and early 20th centuries. One of his principal contributions has been to show that changes in thinking about substantive due process necessitated revisions to Commerce Clause jurisprudence and vice versa. To one like myself, whose main interests lie outside constitutional law, Berry's contribution is perhaps more general. He has persuaded me that what I learned in law school about the development of constitutional doctrine during the New Deal was not merely oversimplified, but ahistorical. Legal scholars and historians have been guilty of concluding that because they cannot take seriously the private-public distinction, that lawyers and judges of the late 19th and early 20th centuries must not have taken it seriously either. But Berry helps us to see that the standard account must assume that generations of lawyers developed an elaborate set of constitutional doctrines, taught them in law schools, and argued them in court, but were actually speaking a foreign language whose real purpose was to hide their class biases, somewhat as Russian aristocrats spoke French, not merely to appear sophisticated, but to make sure that their own servants could not tell what they were saying. While, as Berry points out, we can't absolutely reject this argument, he has certainly laid bare how extreme an argument it is. Berry has revitalized the position that the internal logic of legal doctrine makes a difference, and that it did so during the Progressive and New Deal eras. He has defended that point with care and elegance. We're fortunate to have the opportunity to hear from him today.
Thank you, Dean Mahoney, for that exceptionally generous introduction, or should I say merci beaucoup. And thank you all for coming out on a beautiful afternoon when I'm sure many of you have more pressing matters to attend to, tomorrow being April 15th. It's my great and undeserved good fortune to be with you all this afternoon with my family, my wife Patty and my daughters Helen and Lydia, with current and former students that it's been my pleasure to teach, and with my colleagues here on the faculty and staff of UVA, with whom I've been privileged to associate for many years. As I look around the room, I'm reminded that a number of you were my teachers, and so knew me back in law school when I was devoting perhaps a little more time and attention to things like softball and the Libel Show band than I should have. And so I'm especially delighted that you all can be here this afternoon to join me in relishing the sheer improbability of this event. As some of you know, I've been working on a book project that is tentatively entitled Outlaws of Commerce, Federal Power and Social Reform in the Progressive Era. The book is principally about uses of the commerce power to address a series of social problems by prohibiting interstate shipment and transportation of disfavored articles like liquor and lottery tickets and impure food and drugs. But the story of federal efforts to stamp out child labor in manufacturing lies at the center of that account. In the course of my research, I've learned two things that I'd like to share with you today, and one of them was alluded to by Dean Mahoney in his opening remarks. The first is simply a confirmation of something that I believe for some time and have written about in other contexts, and that is that there is a fundamental problem with our conventional pedagogy of American constitutional law. We organize our presentation of doctrinal development in terms of separate categories of doctrine: the commerce power, the taxing power, the spending power, the the Dormant Commerce Clause, equal protection, due process. And then study each of these doctrinal areas from their earliest expression to their most recent elaboration. And the examination of a line of doctrine from its source to the present is not without some virtue, but it does tend to impede our understanding, our historical understanding of constitutional law. The justices of the Supreme Court did not first decide all of the Commerce Power cases, and then decide all of the Dormant Commerce Clause cases, and then turn to the growing backlog of due process cases. They were deciding all of these types of cases concurrently. Rather than simply developing lines of doctrine, they were elaborating web-like structures where strands were interconnected, interdependent, mutually informative, and often mutually constitutive. This meant, for example, that one frequently could not really understand what was going on in Commerce Clause doctrine without, at the same time, understanding what was going on in due process jurisprudence, and conversely. It also meant that changes in one line of doctrine could have significant ramifications for developments in another line of doctrine. In short, our conventional pedagogy invites us to employ a kind of doctrinal tunnel vision when what is called for is the exercise of peripheral vision. My second observation can be expressed more concisely, and that is simply this, that one cannot understand the story of federal efforts to regulate child labor without first understanding the struggle to regulate convict labor. It's on that latter story that I'd like to focus this afternoon. I won't have much to say about child labor, though my remarks may enable you to draw some inferences about my views on that matter, and that's fine so long as you promise not to steal my ideas. Nor will I have a great deal to say about the Commerce Power. I'd like instead to situate the convict labor story in the context of the developing historiography of the 14th Amendment. Until the last quarter of the 20th century, it was a commonplace that the various expressions of economic substantive due process that we associate with the so-called Lochner era were animated by laissez-faire economics and social Darwinism. You may have heard this view expressed more recently, but most, if not all, constitutional historians of the period no longer believe it to be accurate. It turns out that the court as a whole and the justices individually voted to uphold many, many more instances of governmental regulation of the economy than they voted to invalidate, and that the closest thing to a social Darwinist the court had to offer was Justice Holmes, on whose polemical dissent in Lochner the conventional wisdom had been based. Led by my colleague Charles McCurdy in the 1970s and continuing in subsequent decades, revisionist scholars came instead to see these doctrines as expressions of what Howard Gilman has called the principle of neutrality. That master principle was grounded in such antebellum ideological concerns as the Madisonian aversion to factional politics and the Jacksonian revulsion against special privilege, and was best understood as prohibiting what was at the time called class legislation, or special legislation, or partial legislation. That is, legislation that could not be deemed public regarding because it singled out particular groups for unjustified special benefits or burdens. On this view, economic substantive due process was concerned primarily with formal equality, but a number of revisionists recognized, as the doctrine of liberty of contract would suggest, that such an explanation was incomplete. These scholars understood that the court's due process jurisprudence was also devoted to the protection of liberty, especially so in the context of employment. And they traced that feature of substantive due process to the anti-slavery, free labor ideology of the antebellum Republican Party that informed such landmarks of Reconstruction as the 13th and 14th Amendments and the Civil Rights Act of 1866. At the center of that ideology lay the conviction that the essential characteristics distinguishing the free man from the slave was self-ownership, particularly the ownership of one's own labor. Self-ownership entailed the right to dispose of one's labor on terms of one's own choosing, and regulations of that right that could not be justified as preventing fraud or protecting public health or safety or morals were mere meddlesome interferences with a fundamental liberty of free men. On this account, then, free labor ideology in the postbellum period operated as a shield, restraining the state from interfering with individual liberty. Advocates of prison labor reform, by contrast, were more interested in exploring the implications of free labor ideology as a source of state power to restrict rights of property and contract. Throughout the 19th century, organized workers agitated for the reform of the system of convict labor, contending that goods manufactured with cheap prison labor competed unfairly with goods produced in the private economy and thereby depressed wages. They viewed convict labor as a species of slave labor, that threatened to degrade free laborers, impeding their capacity to acquire capital and to enjoy the upward social mobility that free labor ideology promised to industrious, disciplined workmen. The state of New York became a national leader in this reform effort. The legislature abolished various objectionable forms of convict labor and prohibited the sale of goods manufactured in its prisons on the private market. Convict-made goods produced in other states and shipped into New York, however, continued to compete with products produced by free labor in New York. And the New York statutes regulating the sale of these out-of-state goods raised contentious issues under both the Dormant Commerce Clause and the 14th Amendment. As Professor William Nelson has argued, the late 19th century jurists viewed the inherent individual right to freedom of contract as embracing the right to use and dispose of property. Every man had a natural right to sell or keep his commodities as best suited his own purpose. The right to use and dispose of property was viewed as a necessary consequence of the right to acquire and hold it. The question presented under the 14th Amendment was whether New York's efforts to protect its free laborers deprived the owner and seller of convict-made goods of property rights without due process or denied him equal protection of the laws. Put another way, the question was whether free labor ideology operated not only as a shield, but also as a sword, underwriting police power regulation of private property. Our story begins in 1894, or at least that's where I'm going to begin the story, with the country in the grip of a severe economic downturn, when the voters of New York adopted an amendment to the state constitution mandating what was called the state use system of convict labor. Under the terms of the amendment, the state was forbidden after January 1st of 1897 to hire out the labor of its convicts to private parties, and goods made by convicts in state institutions could be disposed of only to the state and its political subdivisions and not placed on the private market. No one doubted that the state possessed the authority so to restrict the sale of goods produced in its own prisons. Whether New York could regulate the private market in goods produced in the prisons of other states and then shipped into the Empire State, however, was another matter. In the case of Licey against Hardin, decided in 1890, the United States Supreme Court had held that the Dormant Commerce Clause prohibited states from regulating the sale of alcohol shipped into a dry state from a wet state, so long as the booze remained in its original package. Congress removed this Dormant Commerce Clause disability with the Wilson Act the following year. That statute, which allowed state regulatory authority to attach to liquor in its original package upon its arrival and delivery in the state of destination, was upheld by the Supreme Court in 1891. Reformers recognized a cognate problem with respect to convict-made goods, and the success of this strategy of divesting liquor of its interstate character upon its arrival in the destination state prompted a decades-long effort to secure a comparable bill for the products of convict labor. In fact, federal efforts to regulate interstate commerce in prison-made goods had begun in 1888. In March of that year, the court had handed down a decision foreshadowing its decision in Licey against Hardin. And that May, Missouri Representative John Joseph O'Neill introduced a bill to protect free labor and the industries in which it is employed from the injurious effects of convict labor by confining the sale of goods, wares, and merchandise manufactured by convict labor to the state in which they are produced. In other words, the bill forbade interstate shipment of prison-made goods. The measure never came to a vote, but the remarks of New York Republican Stephen White during the floor debates in the House anticipated the difficulties that members of his state's judiciary would experience when grappling with the constitutional issues presented by statutes regulating the sale of convict-made goods. White professed deep sympathy with the objective of protecting American free labor from competition with convict labor, but he was convinced that the O'Neill bill was unconstitutional. The state which properly punishes its criminals can properly employ them at labor, and the product of that labor is property of equal dignity and consideration under the Constitution with any other product of man's labor, White argued. If Congress, under its authority to regulate commerce between the states, can prevent all commerce between the states in the product of prison labor, it can prevent all commerce in the product of our farm labor or that of our paid operators in factories. No one would argue that Congress could prohibit the interstate shipment of wheat or cotton goods. White insisted, but it necessarily followed that if Congress could prohibit goods manufactured by one establishment from transshipment, we can in like manner prohibit goods from all establishments. He regretfully concluded that the O'Neill bill was unconstitutional because it prevents commerce instead of regulating it, and because it takes lawful property from its owner without due process of law. Dealers in convict-made merchandise acquired lawful property rights in those goods, and the protection of the interests of free labor did not justify governmental abridgment of those rights. A similar question would come to the New York Court of Appeals in 1898. In 1896, the New York legislature enacted a statute making it a misdemeanor to sell or expose for sale goods made in any prison without attaching to them a label disclosing them to be convict-made and revealing the name of the prison in which they had been produced. So the state regime thus prohibited the sale of convict-made goods produced in New York and required the labeling of convict-made goods produced outside the state. One Hawkins was charged with offering for sale a scrub brush produced in an Ohio prison without the label required by the statute. In October of 1898, a sharply divided New York Court of Appeals held that the statute violated the Dormant Commerce Clause. 3 of the 7 judges dissented from the judgment, including Republican Edward Bartlett and Chief Judge and future Democratic presidential nominee Alton Parker. Bartlett contended that the statute did not run afoul of the Dormant Commerce Clause because it was a legitimate exercise of the state's police power to promote the public welfare and prosperity by implementing the deliberate policy of this state that free labor shall be protected from disastrous competition with the convict system, which pays to the workman no wages and therefore finds little difficulty in supplanting the wage earner in the public markets. It was self-evident, he argued, that the protection of free labor from competition with convict-made goods in our domestic markets would promote the public welfare and prosperity. A statute that had as its purpose, in pursuance of an enlightened public policy, to promote and protect the interests of free labor as against convict labor, was surely not beyond the power of a sovereign state to enact. It was most fitting, Bartlett concluded, that the state should protect its citizens and the interests of free labor. The opinion for the majority, written by Democrat Dennis O'Brien, affirmed the appellate division's judgment that the statute could not be sustained as a valid exercise of the police power of the state. Much of Republican Justice John R. Putnam's reasoning for the appellate division would be echoed in O'Brien's opinion. Putnam explained that it had not been alleged in the indictment that the brush was not a good one, was not the same in all regards as that made by other than convict labor. Nor was it claimed to be an inferior or deceptive article. It was an ordinarily merchantable scrub brush. It was not an article clearly injurious to the lives, health, or welfare of the people. Such a merchantable article was an article of commerce, and the police power extended only to property which does not belong to commerce. Because Hawkins' scrub brush was not an outlaw of commerce, the burden the New York statute placed upon its sale offended the Dormant Commerce Clause. O'Brien similarly rejected the claim that the statute constituted a legitimate exercise of the state's police power. It was not claimed, O'Brien observed, that there is any difference in the quality of the scrubbing brush when compared with one of the same grade or character made outside the prisons, nor was there any pretense that this act was passed to suppress any fraudulent practice. The sole purpose of the law was to promote the welfare of the laboring classes by suppressing the sale of prison-made goods. O'Brien insisted that protecting the interests of free laborers in New York was not a police power objective that could justify their state's regulation of interstate commerce. New York could not, he wrote, by hostile legislation drive the cheaper-made goods out of its markets, even though such legislation would increase the wages of its own workmen. Trade and commerce between the states must be left free. A citizen of this state who happens to buy goods made in a prison in Ohio has the right to put them upon the market here on their own merits, O'Brien insisted, and if this right is restricted by penal law, such a law is a restriction upon the freedom of commerce. Now, this holding that the labeling regulation was not within the state's police power to enact might be taken to have implications for its status under the 14th Amendment as well. In its discussion of the Dormant Commerce Clause issue, the appellate division had occasionally made brief statements suggesting that the 14th Amendment's concerns were implicated. That court had opined that Hawkins' merchantable scrub brush was property owned by the defendant, and which he had a right to own, possess, and dispose of without any restrictions whatever. Though the appellate division had rested its decision on the Dormant Commerce Clause alone, its language suggested the possibility that its judgment might also rest on the Due Process Clause. But the fact that a police power rationale did not pass muster under the Dormant Commerce Clause did not necessarily imply that it would not suffice to support state regulation under the 14th Amendment. Licey, for example, prohibited regulation of sales of out-of-state liquor in its original package, but the states clearly possessed the power to prohibit the sale of alcohol over which they had jurisdiction. Similarly, the Supreme Court's decision in the 1898 case of Schallenberg versus Pennsylvania held that the Dormant Commerce Clause prevented the state from regulating original package sales of oleomargarine, but the state was otherwise free to prohibit local sales of the product. Some of my friends have heard me say more times than they like to remember that the key to understanding the constitutional law of this period is to master the disputes over the regulation of dairy products and their substitutes, what might be called the food fight theory of constitutional history. And you probably suspected that I wouldn't get through this without saying the word oleomargarine, and you were right. In any event, O'Brien's holding that the Dormant Commerce Clause issue therefore left open the question of whether New York's labeling statute would be constitutional were Congress to remove the Dormant Commerce Clause disability, or were the prison-made product no longer in its original package. And it was to this question, the due process question, that O'Brien next turned, and he concluded that the New York statute deprived Hawkins of his property without due process of law. The scrubbing brush in question was beyond all doubt an article of property in which the defendant could lawfully deal, O'Brien insisted. Yet the statute forbade him to sell it except upon the condition that he shall attach to it a badge of inferiority, which diminishes the value and impairs its selling qualities. A law which interferes with property by depriving the owner of the profitable and free use of it, or hampers him in the application of it for purposes of trade or commerce, or conditions upon the right to hold or sell it, may seriously impair its value, against which the Constitution is a protection. It was not essential to the public welfare that purchasers be informed of the origin of every article of property, which is the subject of sale, trade, or commerce, and even if it were, such a law could be effective only when applied to all property alike, and not limited to articles made in certain places and by a certain class of workmen. There was nothing in the character or the effect of prison labor to justify legislation requiring the owner of prison-made goods or a prison-made scrubbing brush to label it with the history of its origin and to indicate the place where it was made and the class of workmen that produced it. The statute was therefore, on O'Brien's view, simply an effort to regulate the price of labor by depressing the market demand for goods made by one class of workmen, that is, convict laborers, and thereby to enhance the price of goods made by another class. O'Brien asserted that no court had ever invoked the police power to justify such a statute, and with good reason. For if the wages of labor in a few factories producing goods such as are also made in prisons may be regulated by the police power, then there was no reason why that power may not be used to regulate the rewards of labor in any other field of human exertion. O'Brien proceeded to spin out a parade of objectionable class legislation that might follow. Why not give the workman who has a large family to support, he asked, some advantage over the one who has no family at all? Why not give to the old and feeble a helping hand by legislation against the competition of the young and the strong? Why not give to the women, the weaker sex, who are often the victims of improvidence and want, a preference by statute over the men? Why confine such legislation to scrubbing brushes and like articles made in prisons, when multitudes of men engaged in farming, mercantile pursuits, and almost every other vocation in life are struggling against competition? If the New York labeling statute were a valid exercise of the police power, O'Brien could see no reason why the legislature might not interfere in each of these instances to help those who need help at the expense of those who do not. O'Brien therefore concluded that the statute interfered with the right to acquire, possess, and dispose of property, and with the liberty of the individual to earn a living by dealing in convict-made goods. O'Brien's opinion thus expressly embraced the view that the application of New York's labeling statute to prison-made goods produced outside the state deprived the owner of liberty and property without due process. But no other member of the Court of Appeals joined that portion of O'Brien's opinion. The dissenting judges regarded the state's effort to protect its free laborers as well within the police power, while the other members of the majority concurred only in the Dormant Commerce Clause holding. That is, 6 of the 7 judges of the New York Court of Appeals either expressly rejected or refused to embrace O'Brien's view on the due process issue. The New York appellate courts would not revisit this issue until 1910. People against Raines involved a statute requiring anyone displaying convict-made goods for sale to pay an annual license fee of $500 and to display that license prominently in his place of business. The statute did not implicate the Dormant Commerce Clause because the goods in question had lost their character as interstate commerce and become part of the general merchandise of the state. So the sole question considered by the court was whether the license tax violated the 14th Amendment. Republican Attorney General Edward R. O'Malley defended the statute as a legitimate exercise of the state's police power and the classification as reasonable. O'Malley emphasized that O'Brien had been the only member of the Hawkins Court to embrace the view that the state's labeling statute violated the 14th Amendment, and much of his brief amounted to a rebuttal of that portion of O'Brien's opinion. The history of New York legislation regulating convict labor demonstrated, he said, a long-continued recognition by the legislature and the people of the state that a clear distinction exists economically between goods made by convicts and those manufactured by free labor and in free institutions. Convict-made goods differed from goods manufactured by free labor not merely in that they have a different origin, but more fundamentally in that they are virtually a product of slave labor. It was therefore proper that the dealing in such goods should be limited and restricted for the protection of the labor of our free citizens and the capital invested in our free industries. It was necessary to promote the public welfare and prosperity and to protect free labor and free capital from unfair, ruinous competition with cheaply manufactured prison goods. It was also necessary to protect the consuming public, many of whom prefer to buy goods made by free labor and would not purchase prison-made goods if they knew where they were made. The statute's protection was therefore not merely to the laboring classes, but to the entire community by protecting both the manufacturing industries and the wage earners. It was not an effort to suppress the price of a certain class of labor, but to prevent goods made by convict labor or slave labor from competing on unequal terms without disclosing their origin. The statute sought only to compel convict-made goods to stand before the community on their own merits and with their origin disclosed, and to prevent dealers in them from having an undue advantage over dealers in free-made goods. It was proper, O'Malley argued, to distinguish between dealers in these two classes of goods and compel those handling the products of degraded labor to pay a license fee not charged to other dealers. The cost of producing such goods was lower and their profitability accordingly higher, so that imposing a greater burden of taxation on them was fair. The danger to the welfare of the state latent in prison-made goods, O'Malley concluded, was enough to warrant singling them out from other classes, either for police regulation or for taxation. In an opinion affirmed per curiam by the Court of Appeals later that year, a unanimous 5-judge panel of the Appellate Division rejected O'Malley's argument at every turn. The opinion observed that the obvious purpose of the statute, writ so plain that all may read, was to prohibit by onerous and exasperating restrictions the buying and selling within the state of convict-made goods. The statute's classification, the court found, was unreasonable and capricious. It was based upon the origin of the goods dealt in, without regard to the quality or character or nature of the goods themselves. If such a classification were valid, the court asked, what was to prevent the legislature from requiring a license to sell goods made in a factory employing union labor or non-union labor? Why not, the court asked, single out dealers in goods made in shops employing members of certain races, religions, or political parties? Now, the Raines Court did not consider or pass on whether New York's requirement that convict-made goods be labeled was a legitimate exercise of the state's police power. But the decision did focus on the licensing statute's discrimination between goods made by convicts and goods made by free labor, rather than on the even-handedness of its treatment of convict-made goods produced both within and without the state. This discrimination based on the goods' origin or mode of production, the court held, constituted an arbitrary classification, no different constitutionally from discriminations based on race or religion. Even were Congress to enact a Wilson Act for convict-made goods, the opinion suggested, the singling out of prison-made products for adverse treatment would violate the 14th Amendment. Congressional efforts to pass a divesting statute for prison-made products would continue without success for nearly 2 decades after Raines was decided. In early 1929, however, a bill sponsored by Missouri Democrat Harry Hawes in the Senate and Ohio Republican John Cooper in the House would be enacted. The New York legislature transmitted to Congress a communication urging the bill's passage, and several New York members of the House and Senate spoke in favor of the bill's passage on the floor. Republican New York Attorney General Albert C. Ottinger filed a statement in support of the bill that largely copied O'Malley's brief in the Raines litigation nearly 20 years earlier. Ottinger acknowledged the 14th Amendment obstacle that Raines presented, even were Congress to enact the Hawes-Cooper bill, but he nevertheless urged passage with the observation that the extension of the principles of the police power, according to the adjudications of our Court of Appeals during the last 20 years, has been marked, and it was possible that more weight would be given to O'Malley's argument if the case were tried today. Ottinger recognized that recent changes in the personnel of the New York Court of Appeals had made that court increasingly receptive to a broader conception of the scope of state regulatory authority. This was particularly so with respect to what we might call the constitutional law of competitive injury. Exemplary of this transformation was the 1933 case of People v. Nebbia. That case involved the constitutionality of a New York statute involving setting minimum prices for the sale of milk within the state. So our dairy theme resurfaces. The legislative findings and statement of policy accompanying the statute's regulatory measures referred to unfair, unjust, destructive, demoralizing, and uneconomic trade practices carried on in the production, sale, and distribution of milk in the state, which called for an exercise of the police power to protect the public welfare. Oversupply led distributors to offer prices to farmers that were below those at which milk could be produced profitably. The farmer was unable to protect himself from these exactions, and the minimum price regulation was therefore necessary, the legislature concluded, to keep open the stream of milk flowing from the farm to the city and to guard the farmer from substantial loss. The Court of Appeals upheld the statute by a vote of 5-1. Chief Justice Judge Cuthbert Pound wrote for the majority that doubtless the statute before us would be condemned by an earlier generation as a temerarious interference with the rights of property and contract, citing the Supreme Court's opinion in Lochner against New York. But we must not fail to consider, he continued, that constitutional law is a progressive science. The statute's aiming to establish a standard of social justice, to conform the law to accepted standards of the community by fixing living standards of prices for the producer, are to be interpreted with that degree of liberality which is essential to the attainment of the end in view. The Due Process Clause did not leave milk producers unprotected from oppression. The legislature possessed the power to ensure that a fair return may be obtained by the producer and a vital industry preserved from destruction. Though the Hawes-Cooper Act was enacted in 1929, its terms provided that it would take effect in January of 1934. In the meantime, several states, including New York, enacted statutes prohibiting the sale of convict-made goods on the private market within the state after the effective date of the act. And on January 5th of 1934, the New York Supreme Court in Albany County ruled in an action to restrain enforcement of the Hawes-Cooper Act and New York's new statute. The case was argued before Justice John T. Loughran, who within a matter of months would be elevated by Governor Herbert Lehman to the state's Court of Appeals. In a brief opinion, Loughran rejected the contention that the New York convict labor law was obnoxious to the Due Process Clause. The statute declared it to be the policy of the state to protect free labor from the unjust competition of convict labor, he wrote. It was sound to keep convicts at work, but the products of free labor had to be marketed at a profit. If there was a conflict between these objectives, the choice was for the legislature. Loughran pointed out that in Hawkins, Judge O'Brien had been alone in taking the position that the labeling statute amounted to a denial of due process, and he brushed aside the Raines precedent with only a brief mention. The relief sought was therefore denied. 2 years later, Loughran would again support the use of the police power to prevent what he characterized as unjust competition in the labor market when he joined Judge Irving Layman's dissent from the majority opinion invalidating New York's minimum wage statute for women in the case of DePaldo against Moorhead. Layman observed that the legislature had found that the constant lowering of wages by unscrupulous employers constitutes a serious form of unfair competition against other employers, reduces the purchasing power of the workers, and threatens the stability of industry. These evils of oppressive, unreasonable, and unfair wages were such as to render imperative the exercise of the police power of the state. Such unscrupulous employers, Layman argued, forced more scrupulous employers to lower their wages. The legislature could restrain such injurious, unfair, unjust practices in the interests of proper competition. The vicious result of oppressive wages paid to cheap labor extended throughout the industry in question and, in lesser degree, even beyond the industry. Just as experience has shown that in a community where peonage or slavery exists, free labor cannot flourish, so in an industry or even community where oppressive wages are paid to those deficient in bargaining power, it is not unreasonable to believe that such wages affect indirectly, but nevertheless very substantially, the wages of all others. Here, in a nutshell, was the argument against sale on the open market of convict-made goods. And that argument would be echoed the following year when President Franklin Roosevelt called on Congress to enact the Fair Labor Standards Act in order to protect the fundamental interests of free labor and a free people. But one did not have to share Roosevelt's or Loughran's views on the constitutionality of the minimum wage in order to agree with them about the validity of state laws prohibiting open market sale of prison-made goods. The day before the New York Court of Appeals decided DePaldo, the Supreme Court of the United States decided a case involving the constitutionality of the Hawes-Cooper Act and of an Ohio statute prohibiting the open market sale of convict-made goods. The court unanimously upheld both the federal statute and the Ohio law. The opinion was written by Justice George Sutherland, who is often remembered as one of the conservative four horsemen and as a leading proponent of substantive due process, and not without good reason. He had stood foursquare behind the right of liberty of contract in writing the majority opinion invalidating a minimum wage law for women in 1923 in the case of Adkins against Children's Hospital, and he would continue to adhere to the views he'd expressed there until the end of his career. He had authored a series of decisions invalidating price regulation measures in the 1920s, and he dissented when the court affirmed the New York Court of Appeals decision in Nebbia. He would vote to strike down several New Deal initiatives during the Depression decade. But Sutherland was not a dogmatic apostle of laissez-faire. Over the course of his tenure on the court, he, like his fellow horsemen, voted to uphold many more police power regulations than is often recognized. As a member of the Utah legislature and a United States senator, he had supported several pieces of progressive labor legislation, including the Seamen's Act of 1915, which liberated sailors in the merchant marine from various degrading and unfree conditions of service. Labor leader Samuel Gompers later praised the exceptional assistance Sutherland had rendered in the enactment of that legislation, and Seaman Union President Andrew Forsyth acclaimed him as a lover of freedom, a man who understands thoroughly what freedom means, and a man who, in the protection of freedom to all men, regardless of their station in life, may be trusted and relied upon under all possible conditions. Sutherland's opinion dismissed the contention that the Ohio law deprived dealers in prison-made goods of their property without due process. Ohio's view that the sale of convict-made goods in competition with the products of free labor is an evil, he said, found ample support in fact and in the similar legislation of a preponderant number of the states. Acts of Congress relating to the subject, Sutherland pointed out, also recognized this evil. Such legislation proceeded, he said, upon the view that free labor properly compensated cannot compete successfully with the enforced and unpaid or underpaid convict labor of the prison. A state basing its legislation upon that conception had the right and power, so far as the federal Constitution is concerned, to preserve its policy from impairment or defeat by any means appropriate to the end and not inconsistent with that instrument. And because the Hawes-Cooper Act had divested convict-made goods of their interstate character upon arrival and delivery in the state of destination, the Ohio law was equally unassailable on Dormant Commerce Clause grounds. The final episode in the constitutional battle over the regulation of convict-made goods would come the following year in 1937. In 1935, Congress had enacted the Ashurst-Sumners Act, which prohibited the interstate shipment or transportation of prison-made products into any state where the goods were intended to be received, sold, possessed, or used in violation of that state's law. The bill was modeled on the Webb-Kenyon Act of 1913, which had imposed a similar scheme of regulation on the interstate shipment of alcohol, and which the court had sustained against constitutional challenge in 1917. The Ashurst-Sumners bill was signed into law by former New York governor and now president Franklin Roosevelt, who had long been a supporter of prison reform at the state and national levels. The Supreme Court here challenged that statute in the case of Kentucky Whip and Collar against Illinois Central Railroad Company. New York authorities took a keen interest in the case, and the state's Attorney General, John Bennett Jr., filed an amicus brief in support of the act. Bennett's brief placed great emphasis on the power of Congress and the states to protect free labor from unjust and ruinous competition. It was a function of government, he said, to preserve the freedom of labor and to prevent the crushing of free labor in industry. The labor that produced convict-made goods was not free labor, and there was in such labor no inherent rights of men which are subject to the normal protection of the Constitution. The Due Process Clause did not preserve for the convict any liberty of contract or any right of property in his labor or the products of his labor. Accordingly, other persons could not contract with the convict for his labor and thereby acquire rights of property. It was just as proper, he wrote, for Congress to protect free labor against the interstate transportation of convict-made goods as it was to protect free labor against the flooding in from abroad of the products of slave labor. Because convict labor was used to destroy the property of free men in their labor and the property of others in the products of free labor, Congress could, he concluded, protect interstate commerce in the products of free labor from the demoralizing influence of the competitive products of convict labor. The court's unanimous opinion upholding the act was handed down in early January of 1937, less than 3 months before a sharply divided court would uphold Washington State's minimum wage statute for women in West Coast Hotel against Parrish. The author of the opinions in both of these cases was Chief Justice Charles Evans Hughes, who had been the progressive Republican governor of New York and a proponent of penal reform in 1910 when the Raines decision was handed down. His opinion surveyed the court's decisions upholding prohibitions on interstate shipment, reiterating the established principle that Congress could prohibit the use of interstate commerce as an agency to promote immorality, dishonesty, or the spread of any evil or harm to the people of other states from the state of origin. Hughes rejected as inadmissible the contention that the act was invalid because the goods in question were useful and harmless articles. The liquor cases established that booze was a legitimate article of commerce. Indeed, that was why it enjoyed the protection of the Dormant Commerce Clause. But because of the effects ascribed to the traffic in intoxicating liquors, the states could exercise their police power to restrict or prohibit internal commerce in them without violating the Due Process Clause. And the same was true of convict-made goods. Though the subject and the effects of the traffic in liquor cases were different, the underlying principle Hughes wrote was the same. The pertinent point, he said, was that Congress could prevent interstate commerce from being used to frustrate the enforcement of valid exercises of the state's police power. Hughes found in the Act nothing arbitrary or capricious that would bring its provisions into collision with the requirements of due process of law. The Chief Justice noted that congressional hearings held over many years thoroughly revealed the evils attending the sale of such goods in the open market in competition with goods manufactured and produced by free labor. In exercising the commerce power, Congress was, he concluded, as free as the states to recognize the fundamental interests of free labor. As Professor Rebecca McLennan has observed, these decisions sealed the fate of profit-driven prison industries in the United States. State legislatures were quick to react to the opportunities the decisions presented. By the end of 1937, the year in which Kentucky Whip was handed down, only 10 states containing a combined population of only slightly in excess of that of the state of New York permitted the unrestricted sale of imported convict-made goods. Under these conditions, McLennan reports, the interstate market in prison-made goods disappeared in a matter of a few years. and the country's remaining prison industries went into a rapid decline. 25 years ago, Professor William Forbath demonstrated that antebellum free labor ideology left an ambiguous legacy, strands of which were capable of nurturing and sustaining visions of the social order, offering alternatives to the industrial capitalism that emerged from the Gilded Age. That ambiguity, Forbath argued, was resolved in favor of recognition of a right to pursue a lawful calling and to enjoy its market-determined rewards, and against the labor movement's aspiration to protection from the functionally compulsory sale of one's labor into a system of dependent industrial wage slavery. The story of convict labor reform in New York reminds us that the 14th Amendment's ambiguous protections of liberty and property also left open how many questions of law and policy would be resolved within that system of industrial capitalism. Throughout this period, free labor ideology suffused conceptions of both constitutional right and state power in the domain of political economy. For a season, that ideology was a powerful force underwriting constitutional restrictions on government's regulatory competence. But all the while, that rich and multivalent constellation of ideas also supplied a reservoir of state authority to order our economic relations. And that may well be its more enduring legacy. Thank you all for listening.